students and the aspirants of TSPGLCET 2023 for my online class today, that is 5/5/23, Friday from 9:10 p.m. to 9:50 p.m. on the Cisco WebEx platform with my blue link. Host Professor Dr. Mohammed Saheb Hussain. You are welcome to my virtual class and you are hearing me. Participants, are you hearing me? Say yes.
Yes, sir.
Could you see my screen?
Yes, sir.
Could you read what I posted?
Yes, sir. Welcome to the aspirants of the TSPG 2023 for my online classes. Friday from 9:10 p.m. to 9:50 p.m. Cisco web platform with my blue link.
Yes, that is me, Professor Dr. Mohammed Saheb Hussain. Yes, without wasting the time, now let us go to our shooting session. I will drag up and now let us start it. Public international law multiple choice question, and is the part 1. Tomorrow we're going to deal the part 2. Be ready to shoot. First question. The term international law, also referred to as law of nations, was first coined by dash. A. Option John Stark. B. Hugo Grotius. C. Jeremy Bentham. D. Thomas Aquinas. Shoot among the ABCD now. Unmute and shoot means give the answer, which is the right answer for the first question. There is no negative marks, you hunch it. That's why I told you before joining, you read it so that you can shoot it, so practically that you could learn it. Yes? Participants, don't be silent. Your silent will kill me. Even though it is wrong, doesn't matter. At least you can hunch it, anticipate it. Kishore Kumar and Mahendra, unmute and say.
Yes, I think it's
Thomas
John Street.
WRONG, wrong option. Second option.
Hugo Grotius.
WRONG, third option.
Rodson Jeremy Bentham. It is given in
The C is the right answer. Jeremy Bentham is the right answer for the first question. Is it clear? Say yes.
Yes, sir.
Very good. Second question. Unmute and read the second question loudly. Unmute and read the second question loudly.
The term international law, also referred to as law of nations, was first coined by Jeremy Bentham in dash. In which year?
Option A, 1780. Option B, 1781. Multiple choice. Option C, 1782. And the last option D, 1783. Shoot, doesn't matter. Hunch it, anticipate it.
— 1782.
WRONG, second option.
1781.
WRONG, third option.
83.
WRONG, the right answer is
1780.
1780 is the right answer. That is the A is right answer for the second question. Now the third question. Every country is referred to as dash in international law. A, country. Option B, nation. Option C, government. Option D, state.
State D.
State.
Appreciate. It is the right answer. State is the right answer for the international law, we will say. Now the fourth question. International laws are a set of dash that are binding between the countries. Number one, rules. Number two, regulations. Number three, agreements. Number four, treaties. Options goes in this manner. A, 1 plus 2 plus 3. B, 2 plus 3 plus 4. C, 1 plus 3 plus 4. D, 1 plus 2 plus 3 plus 4.
D, sir. 1 plus 2 plus 3 plus 4.
D, 1 plus 2 plus 3 plus 4.
WRONG, second option.
Oh.
Sir, 2
Second
plus 3 plus 4.
option.
2 plus 3 plus 4.
Yes.
B.
2 plus 3 plus 4 is the right answer because rules are there, agreements are there, treaties are there, but I fabricated regulations. So here they say countries, but the appropriate word is between the states. That is a very appropriate word. Okay, doesn't matter. But what is the options given over there? Which is the appropriate word? You have to pick from the A, B, C, D. There is no presumption and there is no assumptions. You pick from the A, B, C, D only. Is it clear? Say yes.
Sir.
The fifth question.
Yes, sir.
The existence of international law is the result of the increased interstate engagement. It mainly aims to maintain international peace and security among the different states. See, here they wrote states. They did not write countries or nations, and state is very appropriate word. It also helps in, number one, promotion of the friendly relations among the member states within parentheses, member of the international community, for example, United Nations. Number two, providing for the basic humanitarian rights. Number three, to solve international problems through the international cooperation. Number four, to use the peaceful methods to settle international disputes are a few of its functions. Options A, 1 plus 2 plus 3, B, 1 plus 2 plus 4, C, 2 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4.
So D, 1 plus 2 plus 3 plus 4.
WRONG.
So
1
2
plus
plus 3
2
plus
plus
4.
4. Option B.
Option B is the right answer. Because if you happen to say 3, to solve the international problems, not the national problems. To solve, I removed the international. I kept to solve the national problems. No, to solve the international problems through the international cooperation. Is it clear?
Clear,
Yes, sir.
Yes, I want to teach you from the different angle so that you could not keep your zero face. When once you see it, the 1, 2, 3, 4, your mind will definitely say, yes, 3 is the wrong answer. Hence the right answer for the fifth question is B, that is 1 plus 2 plus 4. Is it clear?
Yes, sir.
Very good, I appreciate. Sixth question, anyone can unmute and read in sonorous voice?
The state is considered to be the primary and original subject of international law. However, it also regulates the actions of other entities. Answers: 1. Individuals. 2. International organizations. 3. Multinational companies. A. 1 plus 2. B. 2 plus 3. C. 1 plus 3. D. 1 plus 2 plus 3.
Shoot.
Sir, 1 plus 2. A is the answer.
WRONG. Even an individual can approach to the any organization, international organization for the justice. Even an organization can approach to the international organization for the justice. It is a protocol, optional protocol is given. Not necessarily a state should have to go. That means 1 is right, 2 is right, and 3 is right. So the right answer is?
Option D.
Option D, 1 plus 2 plus 3 is the right option. Now next, seventh question. Dash is a supporter of the financial theory, not fictional theory, and believes that duties of the states are ultimately the duty of the individuals of the states, and there is no difference between the international law and municipal law, and have been made to be applicable on the individuals only. Options. Who said? A. Professor Nelson. Option B. Professor Kelson. Option C. Professor Bentham. Option D. Professor Keaton. Who said those words among the ABCD?
That simple words, he said there is no difference between international and domestic laws.
Yeah, because in certain cases, no, when international law also goes with the municipal laws,
Yes, yes, it happens, sir. Correct.
and at that instance, they can use both of them. So now the share has gone. Okay, now I'm again sharing. Yes, I say share content. Did you see my screen now?
Yes, sir. Yes, sir.
Yes,
Yes,
sir. Yes, sir.
because there's some technical problem was there, hence it disappeared. So now it can be used both also in certain cases, and have been made to be applicable on the individuals only. And it is said by who? Professor Nelson, Professor Kelson, Professor Bentham, Professor Keaton. Who said? Sure, doesn't matter. There is no negative marks.
Yes, sir.
Professor Kelson. Option B.
Option B is the right answer. Professor Kelsen said that way, that it can be applied both also in case of the individual comes, in addition to the international instruments. Yeah, the International Court of Justice held that United Nations is a dash and it is a subject of international law, capable of having rights and duties like an individual. An organization also having number A, global person, number B, worldwide person, option C, intercontinental person, option D, international person.
Yes, sir. International
Yes,
person.
you are right. It is an international person because it is an international organization. Otherwise, if it is an individual would be there, then we can say individual, or we can say state, or we can say NGO also. Now the ninth question. Dash, referred as the law of nations in Latin, considered to be those set of rules, part of those portions of law mutually governing a relationship between the two nations and don't form a part of legal code or a statute. That is called A. Just enter genex. B. Just enter intra gentium. C. Just inter gentium. And D. Just gentium. Say loudly.
Just intra gentium. Option B.
WRONG, second option. Second option.
Option C.
No. It is option D. Just gentium. JUS, just space GENTIUM, just gentium. And this which I highlighted here, it is the right answer for the ninth question. Yes, now anyone can unmute and read the 10th question.
In the case of Dash, 1876, Lord Coleridge, CJ, defined international law as a law of nations, is a collection of usage which civilized states have agreed to observe in their dealing with one another.
Options.
Option A, R was a skin. Option B, king was a skin. Option C, queen was a skin. Option D, Regina was a Ken, sorry.
Shoot among the ABCD.
D. Regina versus Ken.
WRONG, second option.
King was a Ken, option B.
WRONG, third option.
R was a Ken, option A.
WRONG. So the right answer is
Queen was a King.
Queen versus King. I don't know whether you know what is meant by R. Supplementary question. If you know it, you tell me. If you don't know it, you say pass on.
Pass on.
R stands for Rex, R-E-X, Rex in Latin terminology. And the equivalent English is King, K-I-N-G, King. And C.
R means respondent, sir, sorry.
No. R means state here. And C, Queen, it is the equivalent English. It is Latin terminology is Regina, R-E-G-I-N-A. Is it clear?
Yes, sir.
11th question. As per dash, I quote, the term international law means the body of rules of law which apply within the international community or society of the states, I unquote. Who said? A. Professor L. Oppenheim. Option B. J.L. Brierley. Option C. Torsten Gill. Option D. Gray.
C.
Right answer is C. Torsten Gill. He said the term international law means the body of rules of law which apply within the international community or society of the states. And he said in that way. Now, the 12th question, I will drag it to the next page. International law can be broadly divided into three types. Number 1, public international law. Number 2, private international law. Number 3, supranational law. Number 4, supranational law. Options: A, 1 plus 2 plus 3. Option B, 1 plus 3 plus 4. Option C, 1 plus 2 plus 4. Option D, 2 plus 3 plus 4.
Sir, C. 1 plus 2 plus 4.
You are right. C is 1 plus 2 plus 4 is the right answer because it is divided into three only: public international law, private international law, and supranational law. I added, I concocted it, I fabricated, I falsified the third, supranational law. Is it clear?
Yes, sir.
Yes.
Yes, sir.
13th question. Austin's view. Option A, international law is not an accurate law. Option B, international law is not a correct law. Option C, international law is not a right law. Option D, international law is not a true law.
Sir, A. International law is not an accurate law.
WRONG. Second option.
International law is not a right law.
WRONG.
D. Not a true law.
Yes, it is the answer D. Austin's view that international law is not a true law. Now the 14th question. Anyone can unmute and read.
According to laws are nothing but a body of rules for human conduct within a community, which can be enforced by an external power if there is a common consent of the community for the same. Answer: Lord Curtain, Lord B, Lord Cockerell, C, Oppenheim,
Oppenheim.
okay, D, Keaton.
Option C.
Right. It is according to Oppenheim. When you are reading, you did not say according to dash. Laws are nothing but, that is the way of reading. You did not read the dash. Okay, now the dash is filled by the Option C, that is Oppenheim, for the 14th question answer. Now, 15th question. Aspects of public international law. Number one, customs, consistent state practices relying on opinions, juries, that is belief that is to be carried out. There is a legal obligation to do so. 2. Standard behavior globally accepted. Number 3. Just gentium. Number 4. Legal codes referred to as treaties. And here I have given the options. A, I will drag it down. Options A, 1 plus 2 plus 3. Option B, 2 plus 3 plus 4. Option C, 1 plus 2 plus 4. And option D, 1 plus 2 plus 3 plus 4. And these are the options. Statements 1, 2, 3, 4. And which is the appropriate answer among this A, B, C, D?
Sir, A, 1 plus 2 plus 3.
WRONG.
1 plus 2 plus 4.
1 plus 2 plus 4 is the right answer because there is no just gentium, but I replaced here just cogents is replaced by just gentium by the host. Just cogent is the right there, but I replaced the just cogent with the just gentium, and hence the right option is 1 plus 2 plus 4 means 3 will be eliminated. Is it clear?
Yes, sir.
Yes, sir.
Yes. Anyone can unmute and read the 16th question.
Private international law. It is also referred to as conflict of laws, and the phrase was first used by Dash in his book De Conflict Ligum Diversarum in Diversi Implies in 1689. Options A, Ulrich Huber, Ulrich Huber, Ulrich Hoyas, Ulrich Hossa.
Sir, C, Ulrich Hoyas.
WRONG, second option.
Option A, Ulrich Huber.
You are right. It is Ulrich Huber. He said, private international law can also be referred as conflict of laws. But we, common law countries, we don't use the word conflict of laws. We use private international law. But most of the European countries, as well as the civil law countries, they use the word conflict of laws. And both are the same, the other name would be there. So we say the private international law. And I am a good in the private international law because in the African continent, I am the first person who introduced this private international law in the University of Dar es Salaam, Tanzania. Otherwise, this subject is an elective subject restricted to the prospectus only. After teaching 2 or 3 years later as an elective subject, then like UGC, University Grant Commission, and here in Tanzania, there is a Tanzania Commission for the Universities. TCU said, no, this course should be a core course, compulsory course. Hence, it should be introduced as a compulsory course. Then all the students should have to take it. But I don't know why India did not make as a compulsory course this, because it will be taught as a part of the public international law. Am I right?
Yes, sir.
But it should be a private international, should be a core course. The UGC should have to make it out. The reason is because now the world is like a hamlet, a small village, and today we take the breakfast in one country and we go to the other country for the business because of the globalization and liberalization, and we take the lunch in another country, but when you go to the another country for the sleeping, because now the world is like a hamlet, a small village, and hence this should be a core course. The UGC should have to make it out. I don't know whether any UGC person has heard my voice. Perhaps he may think over it. Okay, 17th question. People from the different parts of the dash are often interacting with each other, forming a legal relations. Option A, country. Option B, world. Option C, state. Option D, nation. I already repeated.
The
Now
world.
repeated. Yes, it is a world you have to say. We should not say country because world is having many states. World is having many countries. World is having many nations. Am I right?
Yes, sir.
So that is a very appropriate way of giving the shooting the answers. So now 18th question. Anyone can unmute and read the 18th question loudly.
For example,
For example,
an American man and a New York woman were married in India and now live in Los Angeles. In case they ever want to divorce, the rules of private international law will determine where they will be required to go, either to the US or to an Indian court to get divorced.
Option A,
A is it correct?
statement.
Yeah, is it correct
B,
statement? B, is it not correct statement? C, it is a false conflict. D, it is true conflict.
a little bit confusion it is because you did not study as a full course as a private international law. But anyway, you try to shoot
Sir,
it.
I believe, sir. Actually, sir, A answer is it is correct, sir. Actually, A
No,
option is it is correct.
no.
Is it correct?
it is a
Sir,
truly
asking again
true
in
conflict.
the A option.
The reason is, I will tell you the reason. If any conflict comes in the private international law, there should be two different countries, parties should be there. Now, who are the parties here?
Okay.
Who are the parties here? I say American and a New York woman. Is it the different countries?
Okay.
And hence, it is a false conflict.
Sir, one question, sir, out of this question, sir.
Please.
Sir, under the private international law, one need to go to arbitration, sir.
See, the rule says a person who want to get married in another country,
Sure.
the rule says they should have, the statute should allow them to marry, means domicile, where they domicile, and there the law, if it prohibits the marriage celebrated in India, is a void marriage. If the law allows them to marry in different country, means domicile of the country allow the countries, two parties to marry, yes, they can marry. I will give the example, good example. See, gay marriages, whether it is allowed in India,
No, sir.
India-
It's not allowed in India.
but South Africa allowed it. Can the two Indians will come, male and female, or sorry, both male or both female, not gay means no, both male can come to South Africa, get married and go to India, whether it is a valid marriage?
No.
Answer is no, because there are two Indians domiciled in India. The Indian law will not permit them to do so. Hence, the marriage is void. Is it clear?
Clear, sir.
Yes, sir.
Don't you know?
In Supreme Court nowadays, there is a case is going
Yeah.
to recognize that gay marriages.
See, the people, you cannot copy the Western culture. India is having a wide, a good culture, and you don't go against the nature. I repeat, you don't go against the nature.
Correct, sir.
Okay.
And I am full confident of it. Gay marriage should not be allowed. If women are more and men are less, the Hindu law should be changed. Let a man will have the two wives rather than going the other woman as a prostitute. Am I right?
Correct, sir.
You legalize them. They do have the food, they have the shelter instead of going for the prostitution. And the license, how could you give the license to the prostitute? I don't know the Supreme Court why they want to make it out. I am against it. I am condemn it. Totally.
Sir.
Prostitution should not be given. Okay, prostitution is a old fashion. From the beginning it is there, but it is a confidential.
Yes,
You
yes.
following me?
Correct, sir. It
And
needs to
how
happen
could
in
you give the
secret.
license to them? And how could they make the profession? And everybody wants to get the profession because easy way to get the money. And who will take care of it if they have the children? And what will happen to them? Why you create the problem?
In fact, they are
Don't buy the
legalizing it.
tension. Try to resolve it tension, because we are the very uneducated, in the sense we are not fully educated person to know what precautions should be taken when you are going to the prostitute. Am I right?
No idea, sir.
Yes.
Completely zero idea.
Now, globalization has to lead to business activities between the various countries. For example, if you are defrauded by a foreign country, personal, virtual, private entity or organization, then the rules of dash law will apply if you want to use it. A. Municipal law. B. Domestic law. C. Private international law. D. Public international law.
Option D. C or D, private or in public interest?
It is purely a private international law. Because if you bought a BMW, you know what is BMW?
Yes, sir. It's car.
What is that? It is a vehicle.
Car.
It is a car. The BMW, they have the agents in India also. And the BMW is manufactured in Germany. If an accident happened in India, could you go to the Germany and you file a case?
No, sir, not possible every time.
You will file a case in India because the cause of action arose. The reason is the structure of the BMW caused the accident. And you can make the manufacturer is held liable because the wrong design. There are three types of the defects are there. Number one, manufacturing defect. Number two, design defect. Number three, marketing defect. If any one of them is not there, then you can file a case in India. Indian courts having the jurisdiction make the party of the agent who is there in India and make it another party for the producer who is there in Germany. And hence, private international law is very much nice law, and one should have to supposed to study because it is very interesting case law. Okay, now 20th question. It refers to a situation in which a nation, virgule state, surrenders to a court of their choice the right to make certain judicial decisions which will take the priority over the decision made by the national court is known as dash. A. Private international law. B. Public international law. C. Supranational law. D. Municipal law.
Sir, B, public international law.
Repeat.
Sir, B, public international law.
Means B. Public international law.
Yes, sir.
WRONG.
Municipal laws.
WRONG. If you see the definition of the supranational law, it refers to a situation in which a nation or a state surrenders to a court of their choice their right to make certain judicial decisions which will take the priority over the decisions made by the national court is known as supranational laws. The reason is law of contract, general principle are everywhere in the world is the same. If a breach of contract happened in India and other party from say Tanzania, and general principles are common, whatever the decision is there in the Tanzania can be used as an example in India, because to avoid the time waste, to avoid the other litigations. As it is, it can be used as a recognition and enforcement of the foreign judgment, and they can use the judgment in Indian court. and the Tanzanian court supposed to follow the decision. The reason is we have to give the reverence, or we have to give the respect to the decision of the other country, and other country also give the respect to the decision of another country, because Tanzania and India both are
Friends,
Tanzania and India are in the legal system, both are common law system. Both countries are ruled by the English people. Hence, common law would be applicable. Whenever there is a gap, whenever there is a no statute, whenever there is no at the time, common law will be applied in the both of countries. And the blanket principle is justice, equity, and good conscience. That's the blanket clause. And hence, common law never die. I repeat, common law never die. Even if it dies also, it will rule from the grave. Repeat what I said.
Common law never dies.
Yes. Even if it dies, even if it dies, it will rule from the
yes, sir.
Graves.
grave. GRAV. కబరు అంటారు కదండి, బొందబట్టిన దానికి ఏమంటారండి?
అదే సార్, కబ్రస్థాన్.
Yes, that is the wording that you use it. So, this is the 20 questions that I prepared it. And if you happen to watch my earlier questions and you find there is less possibility of the coincidence. And every time when I prepare and design the questions, I design in a different style so that my students should not keep a pale face, a withered face, a zero face when they are facing the examination, because they can shoot from the different angle even though they don't know the answer, but I'm sure that they can shoot it with applying the different equations, different angles like x-axis, y-axis, and z-axis. In the three-dimensional way, they will look at the point and they will shoot at the right option. So this is the 28th questions, and you know how to see my earlier videos. Do you know how to see my earlier videos?
YouTube, sir. YouTube. I think you have channel.
Yes, just you can go Google search engine and you type my name. What is my name?
Yes, sir. Full name.
Mohammed Saheb Hussain.
Mohammed Saheb Hussain. And if double click it,
Yes, sir.
see, you will get my blog, YouTube here, Mohammed Saheb Hussain. Did you see it?
Yes, sir. Yes, sir.
Yes,
Click
sir.
it. You double click it, then you will get my blog. And here it is written, in all arms education armies at Zen. सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।